14 32 જામી જામી લગી 14 32 24 વખતથી પીજી જાડે જાય એ પીજી જાડે જા ये सर कागज नहीं लगती है साइड पर आप सुपास की लगता है तो 33 तो कैसे एमएस पढ़ा के ये पढ़ा सेशन 135 21 यानी क्या विशाल सी अजीब चीज गाड़ी या विचार की लगे थे
एक नंबर पर सब वार्ड છે ને બે નંબર નો રિપોર્ટ છે એક નંબર સાહેબ આવા છે હું વાર્ડ રદ કરેલું છે હું આવે છે 135 11 નંબર હા આવે છે મુદત થઈ એક જ મુદત છે એક મુદત છે બે આમ 17 तारीख मतलब सब नाम अगली मुद्दे सब आया तो नामदा को सब रजा बदले में रद्द नहीं तो कराया किसी जी सर
सेशन 150 21 रवीना बंटी सिंह ठाकुर रवीना बंटी सिंह ठाकुर किशोर कुमार फतेह ओके से आरएन बारूद ओके आरएन बारूद सेशन 22 दोनों की हिम्मत से गुलाब थी बोला कि हिम्मत से गुलाब ने तो आप आई डोंट नो मैं आते आ आजी आजी असर में अगो पर इस भगोल शुद्ध पहला बोला था आपने साक्षी तरीके बोला था पहले आगे आओ भाई अगो पर दे रखा हिम्मत से सेशन 15-22 डिग्री सीडी अरविंद गिरी डिग्री अरविंद गिरी
3 नंबर नो रिपोर्ट आज
डिग्री सीडी भरत गिरी आयो सीके पड़े आयो सीके पड़े टाइम की आवश्यकता नहीं टीचर तो क्या होगा आयो सीखो होई मुझे तरह के आदे मैं काटता हूं तो ये पूरी वो चीज नहीं काटता हूं पूरी सीखो तो क्या होगा
16-24
26 4 થી સાહેબ ચાલે છે આજના સાક્ષી પર ચોથા મહિનાથી એમના નવી ચારે સમજ પહેલો ઇશ્યુ એક રિપોર્ટ આપ્યો તો સાહેબ એને કે તમે બીમાર હો તો ખુલાસા સાથે જરા મેડિકલ સર્ટિફિકેટ લઈને આવું એવું અરજી આપી દો બીજાને એવું કાઢી
અરજી આપી દો
એવું અરજી સાહેબ આપી દો ખુલાસા માટે 28-29 બંને કાઢી દેવું છે બંને કાઢી 29 વાળા છે ગમે ત્યાં
सेशन 24-22 राठौर राहुल भाई चमन भाई राठौर राहुल भाई चमन કરવાની દલીલ તૈયાર 307 ને માથામાં પાઇપ થાય હવે તો સાહેબ શનિવારે હવે જોઈ લઈએ કારણ કે મારે હવે પવાન સાહેબ જ રહેવાનું છે નામદાર કોર્ટમાં ભરતભાઈ અને આજે પહેલી એસ આર પટેલ સાહેબ અને ભરતભાઈ સાહેબ તો મારા એક બે દલીલ નું મારે જોડે રહેશે સાહેબ જી જી ઓકે જી ઓકે
5722 વિરુદ્ધ કુમાર કંસુપી રબારી
નંબર
એક
કે આદત છે તો ઇન્ફેક્શન થયું છે એટલે બીમાર છે નંબર 3 નો રિપોર્ટ
વિરુદ્ધ કુમાર ધરમસિંહભાઈ સરકાર ઇન્સ્પેક્ટર શ્રી દલવીરસિંહ હરીસિંહ
જી સર
635822 મુકેશ કુમાર રણછોડભાઈ મુકેશ કુમાર રણછોડભાઈ રમેશભાઈ રણછોડભાઈ ધ્યાનજીભાઈ અર્જુનભાઈ મોહનભાઈ
મોહનભાઈ નું હા 4 નંબર 2 નંબર નો રિપોર્ટ હા લઈ
ઇતિહારી 324 રણજીતભાઈ સાનુભાઈ
હાજર
આપણા દીક્ષિત નો નહીં હું રિપોર્ટ આપું છું 2 નંબર આવી ગયું સાહેબ મેં વોરંટ રદ કરાવી હતું રિપોર્ટ આપી દઉં સર જી સર જી
હાજી સાહેબ આગામી હું અરજદાર વિરુદ્ધ કડી પોલીસ સ્ટેશનમાં સાહેબ પ્રોહિબિશન એક્ટની કલમ 65 81 83 મુજબનો ગુનો નોંધાયો છે આગામી 11/9/2024 થી સાહેબ જ્યુડિશિયલ કસ્ટડીમાં છે છેલ્લા 9 દિવસથી સાહેબ અમે જ્યુડિશિયલ કસ્ટડીમાં છીએ સાહેબ ના કામે મુદ્દામાલ જોઈએ સાહેબ ગાડીનું સાહેબ મુદ્દામાલ પીએનની ટીમને સાહેબ મુદ્દામાલ પકડાવ્યો સાહેબ કિંમત છે સાહેબ કુલ મુદ્દામાલ 95,000 સાહેબ મુદ્દામાલ છે સામે સાહેબ અમે નાસી ભાગી દઈએ એવા નથી સાહેબ નામદાર કોર્ટ જે પણ શરતો ફરમાવે તમે ચુસ્તપણે પાલન કરી શકો જામીન ઉપર મુક્ત કરવા માટે સાહેબ ટ્રાયલ બાય જીએમએફસી છે સાહેબ નામદાર કોર્ટ જ્યારે ટ્રાયલ ચાલશે ત્યારે પૂરી દર મુદતે હાજર રહીશ
સર મુદ્દામાં છે 90,045 નો 3 આરોપી છે, એમાં એક આરોપી પકડાય, હાલના આરોપી પકડાય છે, 2 આરોપી પકડાવાના બાકી છે. આમનો રોલ છે સાહેબ વેચાણ કરવા માટે મુદ્દામાલ મંગાવ્યો અને મંદિરની બાજુની પાર્લરની ગલીમાં આ આરોપી અને બીજા આરોપીઓ માલ ઉતારતા સ્વિફ્ટ ગાડીમાં. એટલે સ્વિફ્ટ ગાડીમાં માલ ઉતારી રહ્યા હતા, પોલીસે આ લોકોને રેડ પાડી એટલે ગાડી મૂકી અને આ લોકો ત્યાંથી ભાગ્યા. એમાં હાલના આરોપી જે છે સર, એ જે જગ્યાએ માલ ઉતાર્યો ત્યાંથી 6 પેટી સાહેબ મળી છે ગલીમાં, અને બાકીનો મુદ્દામાલ છે એ સ્વિફ્ટ ગાડીમાંથી મળ્યો છે. અને આ આરોપી સ્પોટ પરથી પકડાયા છે. ગાડી જે છે સર એ રાજેન્દ્રસિંહ ભરતસિંહ ના માલિકીની છે, એની તપાસ સાહેબ બાકી છે, કારણ કે એ બાકી છે. અને બીજા જે 2 આરોપી છે એ પકડાવાના છે. એમાં આની સાથે બીજા એક આરોપી માલ ઉતારતા હતા અને એ રીતે રૂલ છે સાહેબ. 3 ગુના ચુકાદા છે. એક 2012 એક પ્રોહિબિશનનો ઓફેન્સ હતો, એ પૂરો થઈ ગયો છે. એટલે સાહેબ તપાસ ચાલુ છે અને 11/9 ઇન્સિડન્ટ છે અને આરોપી સ્પોટ ઉપરથી પકડાયા છે. 1 લાખ રૂપિયા મુદ્દામાલ છે તે સંજોગોમાં એ રિજેક્ટ કરવાનું.
પ્રોસેસ 150 એકવીસ આરોપીને રિપોર્ટ આપ્યો ને દલીલો માટેનું હતું સાહેબ, દલીલો માટેનું 150 એકવીસ. હા સર.
સેશન 3/22 કોઈનો કદાચ બોલાયા નથી કે આયા નથી. ઓકે ઓકે. તો સાહેબ એમાં તારીખ દિવાળી પછી એટલે જે આપનાર એટલે એના ઉપર જ ને કોઈ વીકનેસ નહીં.
પણ મેં કહી દીધું તો છે જ નહીં. જે પેપર છે મારી જોડે મારે ફાઇલ જોઈ લો.
ફોર્મલ ખાલી ડિપ્લોમાઇઝેશન.
જી જી. આમાં PS1 દલવીરસિંહ આવ્યો એટલે સબ
દલવીરસિંહ હરીસિંહ હરીસિંહ ચૌહાણ 51 ASA મહેસાણા એ ડિવિઝન. મહેસાણા હેડક્વાર્ટર.
ખોટું બોલું તો ભગવાન
ખોટું બોલો તો ભગવાન છો.
લખાવો કઈ તારીખે કયા પોલીસ સ્ટેશનમાં કયા હોદ્દા પર હતા?
મેં 3/4/2022 ના રોજ 20 થી PSO ના 3/4/2024. હા હા 22 20 થી 24 થી સવારે 8 વાગે. રોડની હાઈટ. સિવિલ
હા એ લખાવો. કઈ સિવિલ?
મહેસાણા સિવિલ
મહેસાણા સિવિલ
હોસ્પિટલ.
હોસ્પિટલથી ડોક્ટર શ્રી જેડી ઝાલા સાહેબના ઓની લખાવ્યું ની સૂચનાથી WHC વુમન હેડ કોન્સ્ટેબલ આશાબેન નાથુભાઈ ના હોય વર્ધી લખાવેલ કે દર્દી નામે સંજયભાઈ કરશનભાઈ દેસાઈ ઉંમર વર્ષ 28 રહેવાસી અમરપુરા મહેસાણા વાળાઓને અમરપુરા જતા વળાંકમાં રબારી હોટલની બાજુમાં મારામારીનો ઈજા થયેલ છે અને જે દાખલ હોય અને ભારમાં હોય તેની નિવેદન લઈ આગળની કાર્યવાહી કરવી. સદર વર્ધી અમોએ સ્ટેડિયમ નોંધ કરેલી પહેલા
ના ત્યારે દવાખાના વાળી.
દવાખાના વર્ધી નોંધ કરેલી
હા
અમોએ સ્ટેડિયમમાં નોંધ કરી
દવાખાના
નોંધ કરી ઇન્ચાર્જ પોલીસ શ્રી BM પટેલ સાહેબ નાઓને સદર વર્ધી થી આગળની કાર્યવાહી કરવા રિપોર્ટ કરે. મને 9/1 વાળી દવાખાના વર્ધી બતાવવામાં આવે છે. તમારી સહી એમાં મારી સહી જે સહી ઓળખું જે રજૂ દાખલા આજે ઉતાર
એક ક્રોસ વાળો
ક્રોસ 113 સદર વર્ધીના આધારે પોલીસ શ્રી BM પટેલ નાઓ સિવિલ હોસ્પિટલ મહેસાણા સિવિલ હોસ્પિટલમાં ગયેલ અને ઈજા પામનાર સંજયભાઈ ઉર્ફે કાળુભાઈ રબારી નાઓ સારવાર હેઠળ હોય તેઓની પૂછપરછ કરી રૂબરૂ મળી તેઓના સંજયભાઈ ઉર્ફે કાળ રબારી નાઓને રૂબરૂ મળી તેઓએ લખાયા મુજબની ફરિયાદ લખી લઈ જે ફરિયાદ અમોને સ્ટેશન ડાયરીમાં નોંધ કરવા આપતો અમોએ સ્ટેશન ડાયરીના પાન નંબર લખાવો. કયા પાન નંબર?
એન્ટ્રી નંબર 24.
હા એટલે સ્ટેશન ડાયરીમાં પેલી લાયા નહીં એટલે સ્ટેશન ડાયરીમાં લખજો.
એટલે પેલી નહીં
સ્ટેશન ડાયરીમાં તારીખ 3/4/22 ના રોજ અનુક્રમ નંબર કેટલો કીધો? અનુક્રમ નંબર 24/22 કલાક 23:50 વાગે મહેસાણા શહેર એ ડિવિઝન પોસ્ટે ગુના રજીસ્ટર નંબર પેલો
આખો લખો
હા આખો લખો
11-20-60
પાટે કહું
પાટે એ પાટે
પાટે
11-20
11-60
44
44
220
220
312
312
22
ઇપિકો કલમ
143 147 148 149 307 325 જીપી એક્ટ 135
મુજબની નોંધ કરી આગળની તપાસ કરવા સારું ઇન્ચાર્જ કોઈ શ્રી
બીએમ પટેલ
બીએમ પટેલ સાહેબ મહેસાણા શહેર એ ડિવિઝન પોસ્ટે નાઓને ડેપ્યુટ હુકમ કરે મને માર્ક 9/5 બતાવવામાં આવે છે જે ડેપ્યુટ હુકમ છે જેમાં મારી સહી છે જે સહી ઓળખું રજૂ દાખલા કરશે બીજું છે તમારું કઈ આવી આ તમારું
રહો
મને ત્યારબાદ લાગતા એમાં ત્યારબાદ લાગતા વળગતા મેસેજ કરેલ મને માર્ક 9/6 બતાવવામાં આવે છે જે ગુનાનો સ્પેશિયલ રિપોર્ટ છે જેમાં મારી સહી છે જે સહી ઓળખું જે રજૂ દાખલા 69 એ સિવાય છે બીજું
ના એ સિવાય કશું
55 કોઈ
ના
કર્યું હોય,
એ બધી
બીજું
સાહેબ
કોઈ કર્યું હોય. હું આજરોજ મારી સાથે સ્ટેશન ડાયરીની ઓનલાઈન કોપી ડાયરી ઓનલાઈન કોપી લાવેલ છું જે અસલ પરથી ખરી ન કરતા રજૂ કરું છું જે રજૂ દાખલા આ એક બે ભેગી નહીં
ના ત્રણે અલગ અલગ છે
અચ્છા
3 કોપી
તમારું
ના બસ બીજું કશું
બસ
જો આજે દવાખાનાની વર્દી આપના રૂબરૂ મળેલી નથી તો વાત સાચી
ના સિવિલ હોસ્પિટલ માંથી આવેલી
જે લેખિત ફરિયાદ હતી એ પણ લેખિત ફરિયાદ મળેલી ને નોંધી એ સિવાય બીજું કોઈ કાર્યવાહી કરેલી નથી
નોંધીના ડેપોટ હુકમ આપે
બીજી કોઈ કાર્યવાહી કરેલી છે બસ
હાજી
કોપી મારવાનું છે તે કીધું આપણે
રજીસ્ટર નંબર
હા તમારું હા એ પણ કોપી એની કોપી
કાર્યવાહી તમારી સાથે ડેપોટ હુકમ જ કરી આપે હા ભાઈ અહીં લાયક સ્ટેશન ડાયરી લાયક કે આપે હા
કામ વાઇઝ લાઈન નંબર 11
against the present appellant, for which an application was preferred to quash the order dated 4/3/2023 of expiry, against which orders came to be passed in March of 2024, rejecting my application, against which the present appeal. Before I take your lordship to the facts of the case or the order, I would like your lordship first to see the law. And before that, I'll just say in brief what the exact facts. My case is all about the fact that there is not been a proper service which was required to be affected under Order 29, Rule 2 of CPC. Your lordships are very well aware of the fact that once the Commercial Courts Act came into picture, there were certain amendments which were carried out in CPC, which were, as far as commercial court is concerned, as those provisions are to be required to be seen. Other than that, the provisions of CPC are required to be applied, which are not amended. As far as Order 29 Rule 2 is concerned, the same is not amended, so we are required to look into as far as the CPC is concerned. Admittedly, the suit which was filed by the bank had filed a suit seeking for recovery, which is a summary suit. The defendant number one, in most of the cases, there is we are defendant number 3. Defendant number 1 is the original borrower, defendant number 2 is the guarantor. In some cases, there is no guarantor, so borrower and then directly. The role, as far as we are concerned, we are a company which is engaged in the collateral management business. We were the ones wherein the stock was stored. The stock thereafter, whatever amount the banks could recover, we recover by selling and pledging the stocks, by auctioning the stocks. And for the remaining, they have instituted the suit against the borrower. Our case is that the borrower, the guarantor, who had basically given the guarantor, he had played mischief, and he has, so for which a FIR is filed and all those. That is not something which is not concerned. But yes, a suit has been filed for recovery of money, wherein we are shown as defendant number 2 or defendant number 3, and collectively the money is being sought from us. As far as what is there before your lordship today is whether we have been served properly or not. That is the only short answer. That's the issue which is there before. If we are served, then we could not appear before within the stipulated time period, and thereby our right is closed. We are not disputing the contention that yes, the provision contemplates that on summons of service, we are supposed to be filing our written statement within a period of 1 month. There is no dispute to the, because it's a settled position of law in cat and mouse decisions. Now the Honorable Supreme Court has said that yes, once you appear, once you are served with, you are supposed to file a written statement within a period of 120 days. So we have not appeared within, and we have not filed our, that is an admitted position. But today the question is whether there was proper service of summons or not. That's the only limited issue which is there for you. So now for that, I would like your lordships. There is no dispute to the fact I have produced along with my list of documents the registration of the company, wherein it is undisputed to the fact that this is a company registered under Companies Act 1956. The name thereafter was being changed, and there is a change which is done in 2021. But I'm not going into, because change of name doesn't have much to do. As far as the registered office is concerned, which is there in that, the end. Before your lordship, I take your lordship to the civil suit. Your lordship may just turn to the cost guidance in the suit, which has been given, which is at page 14. 14. In my list of documents, page 1.
Yeah, indeed, this is the 40th order. Which case you are referring? So there are around about 90 cases.
May I request your lordship to take a seat?
Take only one case, so. Take number 43.
May I request your lordship to take case number 42.
42.
Commercial civil appeal number 42. Because that's commercial civil suit number 1 of 2023, in which basically I have made my apologies.
Appeal
number 42.
40. Case number
14 in the list of documents.
the list of document or in the entire.
In the list of documents. I think officer. Okay. So Roots starts earlier, but this is the main where the cost title starts. And if your lordship would see the number 3, what has been mentioned is just the name of the company, National Collateral Management Services Limited, and the address is given. It is not mentioned as to whom it has to be served through, notice to be served through whom, nothing has been mentioned. So once the summons are prepared, summons of the registry of this court will prepare the summons on the basis of whatever has been stated in the cost title. Now, if your lordship would kindly turn to order 29, rule 2. Order 29, rule 2. Order 29 is with regard to suits by or against the corporation. And in that, if your lordship would see rule 2, service on corporation. Subject to any statutory provision regulating service of process, where the suit is against a corporation, the summons may be served A, on the secretary or on any director or other principal officer of the corporation, or subclause B, by leaving it or sending it by post addressed to the corporation at the registered office, or if there is no registered office, then at the place where the corporation carries on a business. In this case, what has been done is, if your lordship, I just showed your lordship the cost title in the suit. The cost title provides the registered office. It has been sent to the registered office. So what has been done is subclause B, but not subclause A. Now, in view of this, if your lordship would see what the Supreme Court says. This is a decision PIR 1980, volume 3, Supreme Court cases 595. May I request you, lordship, because this is a vital decision on this point. So I will just, it's a short decision, but so I like to read from para 2 years. Para 2 is the facts. The respondent filed a suit at Indore on so date against the appellant, claiming damages to the tune of ₹26,000 on account of the alleged non-delivery of certain goods. Summons in the suit was sent to the registered office of the company in Calcutta and is said to have been served on one Shri so-and-so on March so-and-so, asking the company to appear at Indore for settlement of the issues. Since the company did not appear in the court on that date, eventually the ex parte decree was passed on so-and-so. According to the case of the appellant, the company came to know about the ex parte decree for the first time when its constituted attorney, Shri so-and-so, received a notice from the respondent by registered post demanding the decretal dues. Thereupon, Shri so-and-so, the works secretary of the company who is in charge of the legal matters, was sent to Indore to assess as to how the ex parte decree came to be passed. So-and-so learned that there was a mere office accountant in the sales department of the company. He was neither a secretary nor a director nor any other principal officer of the company authorized to receive summons in the suit. He did not bring the fact of the receipt of summons by him to the knowledge of any responsible officer of the company. The company remained in dark and, as stated above, learned for the first time on so-and-so about the passing of the ex parte decree. Now, if you also can directly turn to para 4 here. The High Court, in its impugned judgment, has held it is not in dispute that the person who received the summons in the office of the company is not a person who is entitled to be served on the behalf of the company in accordance with clause A of Rule 2 of Order 29 of CPC. The High Court, however, took the view that since Navlakha was an employee of the company sitting in its registered office in Calcutta, the summons will be deemed to have been served on the company within the meaning of the first part of the clause B of Order 29, Rule 2 of the Code. In the opinion of the High Court, since the learned additional district judge did not apply his mind to the provisions of law contained in clause B, it committed a material irregularity and illegality in exercise of its jurisdiction in setting aside the ex parte. In our opinion, the High Court was clearly wrong in upsetting the judgment of the trial court. There was no error in the judgment, much less any error of jurisdiction entitling the High Court to interfere with it. Order 29 of the court is headed suit by or against the corporation. There are only 3 rules in it. We are concerned with Rule 2, which reads as follows. I have read, so I will not bother you also with that. Rule 2 is not an exhaustive provision providing for all modes of service on the company in the sense as to what it meant by service of summons from the secretary, director, principal officer in so and so versus so and so. It was held that principal officer in clause A of Rule 2 would include managing agents, as it can under this rule be on a juristic person. Accordingly, service on managing agents who are a corporation is valid under clause A. Now, if you want to kindly turn to para 8 directly. Sending summons to a corporation by post addressed to it at its registered office may be a good mode of service, either by itself or preferably by way of an additional mode of service. But leaving the summons at the registered office of the corporation, if it literally interpreted to say that the summons can be left anywhere uncared for in the registered office of the company, then it will lead to anomalous and absurd result. It has to be read in the background of the provision contained in Order 5, Rule 17 of the Code. In other words, if the serving peon or bailiff is not able to serve the summons on the secretary or any director or any other principal officer of the corporation because either he refuses to sign the summons or is not found by the serving person even after due diligence, then he can leave the summons at the registered office of the company, make a report to that effect. In the instant case, nothing of this kind was done. It was not the case of the respondent in his rejoinder find in the miscellaneous case that the service of summons was effected. Filed in the miscellaneous case that the service of summons was effected in accordance with the first part of clause B of Rule 2 of Order 29 of the Code. Annexure A to the counter affidavit filed by the respondent in the petition filed by the appellant under Order 9 Rule 13 of the Code in para 9 of the petition was stated inspection of the record of this honorable court relating to so and so so. And thereby, the Lordship para 9. We therefore hold that judgment by trial court setting aside the decree was correct. In any event, no error of jurisdiction was committed by the High Court went wrong in interfering with. We accordingly allow the appeal, set aside the judgment of the High Court and restored the order of the trial court. The suit shall now proceed to disposal with law. We, however, make it clear that the appellant under the orders of the court has furnished bank guarantee so and so. So what this judgment says is, first you need to follow the mandatory requirement of clause A. If for any reason it is not served under clause A, then the procedure contemplated in the clause B, subclause B, is required to be allowed. You cannot simply sit by way of just serving upon the registered office, drop the summons. In this case, if your lordship would see, what has been done is, what is mentioned is the name of the company, the address. To whom it has to be served, the director, the officer, the authorized officer, the secretary, nothing is mentioned. To whom it has been delivered, it has not been explained. The summons has been served by registered post. This, it may have been taken by the peon, it may have been taken by the security. In fact, it is our specific case that the corporate office of the company has shifted to the way back in the year 20, before the switch. But because this is the registered office, we don't dispute the fact that the registered office is situated at that place. But then the registered office, the summons are required to be served in a proper manner to a proper designated person. It cannot be said that the summons can be served upon any person. This view has already also been taken by the Delhi High Court as well as Bombay High Court in two decisions. Delhi is 2002, 96 PLT. 2002, volume 96, PLT, page 668. There is the paras, then I am relying upon. Para 1 is the facts, almost identical. Para 1, 2, 3, and the ratio is para 7. Para 7 and 8. Seven, 8 and 10 in the Delhi. I'll not bother with the lordship with the, I have just given the relevant paragraphs. In fact, para 8 talks about Shalimar, which I just relied upon your lordship, the Supreme Court decision. And if your lordship would kindly turn to para 10 itself. Sending summons to a corporation by post addressed to it at its register office may be a good mode of service, either by itself or preferably by way of an additional mode of service. But leaving the service summons at the registered office of the corporation, if it literally interpreted to say so, the summons can be left anywhere uncared for it in the registered office of the company, then it will lead to enormous and absurd result. It has to be read in the background of the provision as contained in order 5 rule 17 of the. In other words, if the survey peon or plaintiff is not able to serve the summons of the secretary. So again, the what has been stated in the Shalimar, the same has been relied upon in this judgment, and thereafter the, if your lordship, in the present case, if you are para 11, there is nothing on record to indicate that any effort was made to effect the service of summons of judgment on secretary, director, or principal officer of the defendant company. Therefore, the resort to mode of service provided in Schedule B of Order 29 was uncalled for. In the result, application under consideration is allowed. It is held that summons for judgment has not been validly served on the defendant company. Let fresh summons for judgment be issued to the defendant in the prescribed form in accordance with Order 37, Rule 3, 4 of the. So this is what has been. And if your lordship would see the Bombay judgment, 2005, volume 4, MHLJ 156. In that, the facts have been stated in para 2. And 5, 6, and 7 are the. If your lordship would directly come to the para 5. Now, coming to the merits of the case, it is not disputed. There is it is not disputed that the summons was served on one Mr. So-and-so, who admittedly was an employee of the company. It is also true that the defendant did not make any argument in the pleading that Ravi Kumar was not authorized to receive the summons. But it is obvious that the service was not valid in accordance with the provisions of the apex code in the case of so-and-so versus so-and-so held that the meaning of clause B of the code has to be understood with reference to Order 5, Rule 17 of the CPC, and merely handing over of summons to an employee not authorized to receive does not amount to a valid service of summons of the company. The trial court has considered the scope of various provisions and has recorded the finding that the service of the defendant to so-and-so was not. Then there is no reason for this court to take a different view of the matter. Consequently, the CRA stands dismissed. So in that, the trial court had also accepted that that was not a valid service. And that was accepted by the Bombay. Now, if your lordship would kindly turn to now the facts of the case. So, Supreme Court time and again has held that the proper procedure has to be followed. Firstly, the summons are required to be served upon the authorized officer or the director or whosoever is an authorized person to receive the summons. If that is not done, then you can leave it at the register office. But directly leaving at the register office is not a proper service. Now, in view of this, Lordship, what has transpired in the present case? The suit was filed. I was shown the first item. Notice was originally it was a simpliciter suit, which thereafter under order 7/10 was handed over back in view of the implementation of the commercial code. Right? Then a new commercial suits. So the suits ranging from 2020 to 2023 was filed during a different period. There were in all 185 suits have been filed. Okay, the issue is with regard to 97 suits, which where we say that there is not a proper service which has been done. Wherever we could receive the summons, we have appeared and there is no dispute, we have filed a reply. But as far as the other suits are concerned, wherein we could not receive the summons, this is where the whole element has taken place. Now, if your lordship would see the order which has been passed in this matter, the first ex parte order which came to be filed, which came to be passed, was passed on 4th of March 2023, which is on given page number 22. 22. 22 along with my list of documents. Suit ni 25 hai. I took your lordship to the suit which was at page 14. After the suit, any batch hours. I've given the running page under now.
You are talking about running bill?
I'm talking about the running page.
Yes.
20. વાદી તરફે પ્રતિવાદી નંબર 3 સામે આ 10 થી હુકમ એક તરફી ચલાવવાની અરજી આપેલ છે. આજ રોજ હુકમ કરી પ્રતિવાદી નંબર 3 સામે જવાબનો હક બંધ કરી કામ એક્સ પાર્ટી ચલાવવાનો હુકમ કરવામાં આવે છે. So this was the order which was passed on 4th of March 2023. Now, if your lordship would turn to page 24, is my application, which I preferred on 5/7/2023. 24. સાહેબ અપીલ પૂરી સાહેબ પછી કઈ મોકલ્યું છે એપ્લિકેશન ના ઓર્ડર અપીલ પછી એપ્લિકેશન ના ઓર્ડર અપીલ પછી કઈ કારણ કે ઇમ્પ્લિમેન્ટ ઓર્ડર હતો એટલે અપીલની સાથે મૂકેલું તો રનિંગ પેજ છે પણ અપીલ 24 is this is my application. If your lordship would see my applications from para 20 para 2 onwards. નામદાર કોર્ટનો રેકોર્ડ જોતા એવું જણાઈ આવે છે કે દાવાનો સમન્સ પ્રતિવાદી નંબર લઈને બધી ગયેલ હોવાનું માનીને 120 દિવસમાં પ્રતિવાદી નંબર 3 નામદાર કોર્ટમાં હાજર થયેલ ન હોવાના કારણોસર પ્રતિવાદી નંબર 3 સામે હાલનો કેસ એકતરફી ચલાવવાનો હુકમ કરવામાં આવે છે. પરંતુ અમુક પ્રતિવાદી નંબર 3 ની મુખ્ય તકરાર એવી છે કે નામદાર કોર્ટનો સમન્સ અમુક પ્રતિવાદી નંબર 3 ને બચેલ કે હુકુમત ધરાવતી કોઈ પણ કોર્ટના બેલી દ્વારા પ્રતિવાદી નંબર 3 ને સમન્સ બજવણી કરવામાં આવી હોય તેવું કોઈ પણ જાતનો દસ્તાવેજી પુરાવો નામદાર કોર્ટના રેકોર્ડ ઉપર નથી. વાદીના કહેવા મુજબ તેઓ દ્વારા પ્રતિવાદી નંબર 3 ને રજિસ્ટર્ડ પોસ્ટ ઈડી થી સમન્સ બજવણી કરવામાં આવી છે અને પોસ્ટની વેબસાઇટ ઉપરથી ટ્રેકિંગ રિપોર્ટ કાઢીને નામદાર કોર્ટમાં વાદીએ રજૂ કરેલો હોય તેવું રેકોર્ડ ઉપરથી જણાઈ આવે છે. પરંતુ જો વાદીએ પ્રતિવાદી નંબર 3 રજિસ્ટર્ડ પોસ્ટથી સમન્સ બજવણી કરવામાં આવી હોય તો અમુક પ્રતિવાદી નંબર 3 કંપનીની સહી વાળી પોસ્ટ એક્નોલેજમેન્ટ નામદાર કોર્ટ રેકોર્ડ ઉપર આવવી જોઈએ. પરંતુ કોર્ટના રેકોર્ડ જોતા પ્રતિવાદી નંબર 3 ને રજિસ્ટર્ડ પોસ્ટ મારફતે બજવણી થયેલ હોય તેવી પોસ્ટ એક્નોલેજમેન્ટ ઉપર અમારી કંપનીનો સહી તથા સિક્કો હોય તેવું બનેલ નથી અને માત્ર પોસ્ટના ટ્રેકિંગ રિપોર્ટના આધારે સમન્સની બજવણી થયેલ હોય તેવું માનીને સદર કેસ એકતરફી ચલાવવાનો હુકમ કરવામાં આવે છે. તેવા સંજોગોમાં અમોને નામદાર કોર્ટનો સમન્સ બજેલો ના હોય તો 120 દિવસની સમય મર્યાદામાં હાજર થવાનો કોઈ પ્રશ્ન ઉપસ્થિત થતો નથી. તેમ છતાં પણ નામદાર કોર્ટ દ્વારા અમો પ્રતિવાદી નંબર 3 સામે સદર કેસ એકતરફી ચલાવવાનો હુકમ કરવામાં આવેલ છે. તેથી આવો હુકમ સેટ અસાઇડ કરી અમોને બચાવની પરમિશન આપવામાં આવે તો અમો પ્રતિવાદી નંબર 3 ના ખરા અને કાયદેસર હક અધિકારને નુકસાન થાય તેમ નથી. And thereafter, if your lordship would see, below para 3, I have raised all the contentions which I am raising before your lordships as on date. And para 8 was my prayer.
How we come to know that the he has been filed against. આ તારીખે અમને આ ખબર પડી. You have stated in the entire application. How did you know that certain suit has been filed against him?
That is not mentioned. I will not be able to say. But according to what I have been told is because we were appearing in other suits, we came to know that there are other suits, and that's how we came to know. It is not mentioned. If your lordship will then run to the impeach order, which is just behind that. Para 2 years. Not the London advocate for both the sides at length. The London advocate for defendant number 3 has argued, according to his application and has submitted that earlier, the present suit was filed before the civil court as regular to suit, which was written by civil court under order 7 to 10 of CPC. Thereafter, the present commission could launch. The defendant number 3 is summoned by RPA, but looking into the tracking report submitted by the plaintiff, there is no name of defendant number 3 in. The plaintiff has produced any plaintiff has not produced any acknowledgement slip which shows that defendant number 3 has been served by RPA. Actually, the defendant number 3 has not been served summoned as per the procedure, hence the ex parte order passed against the defendant number 3 is required to be satisfied. When the summons is not served to the defendant number 3 as per the procedure, there is no question arises for of 120 days from the date of service of summons. If the ex parte order passed against defendant number 3 is not ordered to be satisfied, defendant number 3 will have to suffer heavy loss. The citation produced by the plaintiff is not helpful to the plaintiff case. Hence, lastly prayed to grant this application. Now, if your lordship would see, in fact, the stand of the other side. On the other side, the London advocate for plaintiff has submitted that earlier the suit was filed as regular so and so before the civil court, which the defendant number 3 has appeared through his London advocate. Thereafter, the regular civil suit as per the order of civil court was written as per the order of civil court. It was firstly kept in pre-institution and settlement in mediation. The case was not settled and hence present commercial suit was instituted in commercial court by plaintiff. The plaintiff has filed more than 185 suits against the defendant number 3 and hence looking to summons in 185 suits and even counting notices in mediation. Around more than 550 summons of notice has been served to the defendant. Therefore, it can prima facie be seen that defendant number 3 is having full knowledge about the present case. Then after the summons duly served upon him by RPD in the present commercial suit, The defendant number 3 has not appeared. Therefore, the court has closed the defendant number 3's right to file written statement and has ordered to proceed ex parte case. The plaintiff has produced original RPD slip and online delivery status from the Indian Post Indian Online Post, which is authentic website of Indian government. The numbers stated in RPD slip and in the delivery status are same. Hence, there is no reason for not believing the RPD slip and the delivery status from the Indian Post site, which is Government of India. In the RPD slip, the name of the defendant number 3 is clearly mentioned. So the argument of defendant number 3 that there is no name of defendant number 3 in the delivery status of Indian Post is not at all valid. Moreover, out of 185 civil suits, in many cases, someone sent to RPD in which RPD slip which is duly acknowledged and signed by the defendant number 3 is also produced. In spite of that, defendant number 3 has not appeared in that case also. Therefore, the defendant number 3 cannot take stand that he was not knowing about the present commercial civil suit filed against him. Summons of the suit has already served to the defendant number 3, but defendant number 3 has not taken due care to appear before the honorable court within stipulated time and has created false story of not service of summons, and therefore the present application is not terminable according to the provision of the Commercial Code Act. The application of defendant number 3 is against the provision of Commercial Code, and therefore such application is not maintainable liable to be dismissed. The honorable court has provided sufficient opportunities to defendant number 3 within the provisions of law, but the defendant number 3 has failed to file reply and contest the suit within the stipulated period, and it is not question of utilizing discretion, and therefore it cannot be utilized at this time. The provision to order 8 rule 1 introduced by the committee is mandatory. So I am not disputing the facts with regard to order 8 rule 1 or order 5 rule 1. As far as 120 days is concerned, in fact, this then your lordship will kindly turn to para 4. Read this application, citation produced by the parties, and entire case record. It appears that the earlier present suit was distributed before the civil court as regular suit, which came to be written by civil court under order 8 rule 10 before the commercial court after following the procedures for pre-institution and settlement. It appears that the order of civil court, the case was kept in mediation as commercial pre-institution mediation case number so which was disposed of on so with report of non-starters. Thereafter, the plaintiff has filed the present suit, which came to be registered as commercial suit number so. The plaintiff applied at its expense summons by RPAD to the defendant number 3, which was granted by this court. And thereafter, the defendant number 3 was issued summons by RPAD. The plaintiff has produced original RPAD slip video mark so and online delivery status from the website and video mark so. The name and address of the plaintiff, defendant number 3 is mentioned.
Okay. I found this on the web for a civil court. The case
Right.
was kept in.
The plaintiff has produced RPD slip and online delivery status from the website of Indian Post. The name and address of defendant number 3 is mentioned by RPD in the RPD slip. The RPD number mentioned in the slip and in the online delivery status are the same. It appears with a mark so and so and so and so. The defendant number 3 was issued summons with a RPD on so and so, which came to be delivered to the defendant number 3 on 11/1/20. From the online delivery status is clear that defendant number 3 was served on so and so. There is no reason for not believing the online tracking report of Indian Post produced by the plaintiff. In spite of the summons duly served to the defendant number 3 constituents, the defendant number 3 has not appeared before the commission. Hence, on 4/3/2023, it was ordered to proceed ex parte against the defendant number. Now, stopping here for a moment, lordships. If your lordship would see what it says is on 7/1/2023, it was the summons was issued, and on 11/1/2023, the summons was served. Now, first question under order 29 rule 2A. This doesn't, the cost title which I took to your lordship, it only says the name. It doesn't say as to whom it was to be served. So the summons would have been prepared only on the basis of the cost. So it has gone to the company, but whom it has been delivered, whether it has been given to a clerk, whether it has been given to served upon the security of the guard of the office, or to some officer, or to some director. It is completely. So today, it cannot be presumed that if the summons has gone in the right hand, or it has been served upon as required under order 29 rule 2 subclause. Till the time the summons is not served in accordance with order 29 rule 2 subclause A, it cannot be said that summons has properly been served. This is exactly what has been contemplated in subclause B. It has been done according to subclause B, yes. But subclause B will come into picture once it has been affected under subclause A and somebody refuses to take the delivery. which has been stated in the judgments which I have relied upon. So subclause B can only be done subject to under subclause A, somebody refuses or it has not been done and the summons could not be served under subclause. First, it has to be done under subclause A, thereafter only subclause B comes into picture because it doesn't say that it is optional, it is mandatory. And thereby, once it is not served under as contemplated under the provisions of the code, then it cannot be said to be a proper service of summons. Now, if you also will take further. Now, what has thereafter been relied upon by the court is para 4.1 and 4.2 is stricter sensu that the Commercial Courts Act provision has to be followed, and the judgment which has been given by the Honorable Supreme. Now, if you lordship would turn on the last page itself, which internal page 40 is mentioned. In view of the above stated provision, the principle laid out in the above cited judgment, after expiry of 120 days from the date of service of summons, has forfeited his right to file written statement. The Commercial Court has no power to extend the time. I am not disputing this fact. The fact and circumstances in the citation produced by defendant number 3 and the facts and so and so are quite different and therefore are not applicable to them. In view of the above discussion, the application filed by defendant cannot be granted following order is passed. The application is so and so. So I am not disputing the fact with regard to 120 days. My only submission before your lordship is that the summons are required to be served in a proper fashion, which has not been done in the present case. And in view thereof, when the summons are not served, there cannot be said my 120 days would start from my service of summons. So till the summons are not served, which is also given under, if your lordship would see the provisions which are under the Commercial Courts Act, order 5 or order 8, in both it is very clear. 120 days from the date of service of summons and expiry of 120 days from the date of service of summons. So even the provisions contemplated under the Commercial Code clearly contemplates from the date of service of summons. In my humble submission before your lordship is the fact that over here the summons itself are not served. When the summons are not served, my 120 days would not start, and thereby the order which was passed ex parte was required to be sent.
What about
And it also
one query is there? What about the mediation? Whether the mediation?
we did not approve.
Mediation. That has also been solved.
Mediation, our case is to the fact that even the mediation notice was not served, that it is not coming out from the record, because it, even the court while passing the order doesn't say that the mediation notice we appeared or it has been served upon us. So that is also our case, that we have not been served even and we did not appear in the mediation in any of the cases. One of the other contention of my learned friend which we will take is with regard to the section 51 and section 20. So section 51 of the Companies Act 1956, which is equivalent to section 20 of the Companies Act 2013. It provides that, so just for your lordships, a document may be served on a company or an officer thereof by sending it to the company or officer at the registered office of the company by post under a certificate of posting or by registered post or by leaving it at its registered office. So section 51 of the Companies Act provides the manner in which but my humble submission to that effect is the provisions of the Companies Act would not come in picture as far as this was concerned. The provision of Companies Act would be applicable when a proceedings are filed under the provisions of Companies. Today, the proceedings which are filed before this are under the Commercial Courts Act, wherein it is a CPC which would be applicable or the Commercial Courts Act would be applicable. When the Commercial Court Act or the CPC itself provides a nature in which a summons are required to be served upon, then in a strictest sense of fashion, those provisions are applicable and you cannot look beyond the said provisions under the provisions of Companies Act, because those provisions would not be applicable as far as the proceedings under the CPC is concerned. As far as the proceedings when you file under the Companies Act, yes, then what is contemplated therein has to be followed in a strict sense of it. So because it's a special act, so the provisions which proceedings which are filed under the Companies Act, in that, yes, the whatever soever the provisions or the procedure which is contemplated under the Companies Act would be applicable, but not when the proceedings are under some different. And when that act itself provides a procedure and a fashion in which a procedure should be followed. Listen, that's
In all cases, you are the party total work.
In all cases. In all cases, we are the parties. Because we were the warehousing company,
How many cases originally you just filed?
185.
In all the cases, you are party.
We are part. Either we are defendant or
You were filed only.
97.
because in those we appear, summons were served and we appeared.
Those you are-
We are appealed.
How could it happen? Dama Bajana, Dama Namaste, all the cases have been filed at the same date?
No, different. In fact, the proceedings have been filed from 2020 till 2023.
Oh,
So some are filed in 20, some are filed in 21, 22, 23. So that's how the cases are basically. So it's not that everything has been filed on one simple day.
oh.
May please. છેલ્લો જે પોઈન્ટ ડિસ્કસ હતો તેને ખાલી ક્લેરિફિકેશન મોટા ભાગના 185 શૂટ્સ જે આફ્ટર કમ્પ્લીશન ઓફ ની પ્રોસીડિંગ કર્યા પછી જે 185 શૂટ દાખલ થયા મેજોરિટી શૂટ્સ વિધિન અ સ્પેન એક જ મહિનામાં 2 મહિનામાં દાખલ થયા છે એટલે એવી રેટ ઓફ ડિફરન્સ એવો મોટો નથી કોઈ જાન્યુઆરીમાં દાખલ કર્યો બીજો સીધો ડિસેમ્બરમાં દાખલ કર્યો હોય એવો કેસ નથી.
But in the other suit, the recharge
Ji.
they have not filed an appeal.
જી
બરોબર છે? In that suit also you have adopted the same procedure as.
yes. Sir, in those cases also, we have mentioned the same name, same address, and same delivery process. There is no change in process of delivery. સાહેબ આ કામના જે અપેલેન્ટ છે એમનો અરજદારનો મુદ્દો એવો છે એમને મહત્વ એમના આર્ગ્યુમેન્ટ ટોટલ મેઇન 5 મુદ્દા છે એસેસમેન્ટ છે કે સામાવાળા બેંક દ્વારા જે દાવો દાખલ કરવામાં આવે એ દાવાનો સમન્સ કંપનીના રજિસ્ટર્ડ ઓફિસને મોકલવામાં આવે કયા અધિકારીને કયા હોદ્દાને એનો ઉદ્દેશથી લખેલો ન હતો એટલે અમને સમયસર મળેલો નથી એવું પહેલું કંટ્રોલ છે. બીજો મુદ્દો એવો છે કે સીપીસીના પ્રોસીજર ઓર્ડર 29 રૂલ 2A મુજબનો સમન્સ કંપનીના સેક્રેટરી ડિરેક્ટર ઓર પ્રિન્સિપલ ઓફિસરને બજાવવો જોઈએ અને અમે એડ્રેસ તમે રજિસ્ટર્ડ પોસ્ટ એડીથી અમે બજાવેલું છે. ત્રીજો મુદ્દો સાહેબ એમને એવો હતો કે 29 રૂલ 2 મુજબનો સમન્સ ત્યારે જ બજાવી શકાય જ્યારે 29 રૂલ 2A મુજબ સમન્સની બજાવણી ના થઈ. ચોથો મુદ્દો સાહેબ એમને એવો છે 29 રૂલ 2A ની બજાવણીનો એનો પ્રયત્ન કર્યા સિવાય ડાયરેક્ટ રૂલ B પ્રમાણે તમે સમન્સ બજાવવાનું કરો એટલે એને પ્રોપર બજાવણી કરી શકાય નહીં. પાંચમો મુદ્દો સાહેબ એમનો એવો છે કે નામદાર કોર્ટ દ્વારા ઇસ્યુ કરવામાં આવેલ સમન્સની બજાવણી રજિસ્ટર્ડ પોસ્ટની પાવતીમાં સહી કોની છે તેનું નામ લખેલું નથી એટલા માત્રથી સમન્સની બજાવણી ના કરી શકે. સર એમનો ઓવરઓલ એસેસમેન્ટ એમનો સારાંશ એવો છે કે નામદાર કોર્ટ દ્વારા ઇસ્યુ કરવામાં આવેલ સમન્સની કંપનીની રજિસ્ટર્ડ ઓફિસે મોકલવામાં આવેલ તેના કોઈ પણ હોદ્દો લખવામાં આવેલ ન હતો તેના પર સમન્સની બજાવણી યોગ્ય થઈ નથી એટલા માત્રથી અમારા 120 દિવસની એ દિવસથી ગણતરી ના થશે. સાહેબ એમની આખી અરજીમાં એમને સમન્સ ક્યારે મળ્યો અથવા એમને બચાવણી ક્યારે એમને જાણ ક્યારે થઈ એનો કોઈ જગ્યાએ ઉલ્લેખ નથી કર્યો અથવા એમને હાલમાં સાહેબ 120 દિવસની વિવાદ એમને બી નથી કે ભાઈ 120 દિવસમાં અમે ફોલ થઈએ તો અમારો રાઈટ ક્લોઝ થશે એમાં એમનું નથી એટલે હું એમાં સાહેબ એમાં ઇન્ટરફિયર કરતો નથી. નોંધો સાહેબ ઓર્ડર 5 CPC ને એમેન્ડેડ પ્રોવિઝન્સ સ્પષ્ટપણે એવું કહે છે કે 120 દિવસમાં જો 120 દિવસની અંદર જો પ્રતિવાદી જવાબ રજૂ નથી કરતા તો even the trial court has no right to extend the time period. સાહેબ કંપનીની મુખ્ય જે રજૂઆત એવી છે કે કંપની સમન્સ બજાવવા સમય સૌપ્રથમ રૂલ ઓર્ડર 29 રૂલ 2A મુજબ જ સમન્સ બજાવવો જોઈએ. જો તેમ કરવામાં શક્ય ન હોય તો જ રૂલ 2 મુજબ સમન્સની બજાવણી થવી જોઈએ. સાહેબ the appellant has clearly misinterpreted the provisions of order 29 rule 2. As per the provisions of order 29 rule 2 of the CPC, where the summons were served on the registered office of the company and were admittedly received by the employee of the company who had exhibited the receipt affixing the seal of the company or signature. It could not be said or held that the service was bad or invalid just because the contravening the provision of order 29 rule of the CPC. Sir, order 29 rule 2 which says No.
એમાં તો acknowledgement તો આવ્યું નથી.
સાહેબ અમુકમાં એક્નોલેજમેન્ટ રિસીવ થયેલ છે કોર્ટ નામદાર કોર્ટમાં, અમુકમાં ઓનલાઈન સ્ટેટસ
That bears signature and
સી
seal. In these 92 cases,
મેજોરિટી કેસીસ હેવ બીન સર્વડ. મેજોરિટી કેસીસમાં એક્નોલેજમેન્ટ પાછું આવેલું છે.
આવેલું છે.
મેજોરિટી કેસીસમાં છે સર, અને બાકીના કેસીસમાં ઓનલાઈન સ્ટેટસ. સર ઓર્ડર 29 રૂલ 2. Subject to any, sir, એનો heading એવો છે, service on corporation. Subject to any statutory provision regulating service of process where the suit is against corporation, the summons may be served. First line, suppose on the secretary or any director or other principal officer of the corporation, comma, as 29 to any વાત છે. comma કરી સાહેબ or લખેલું છે subclause 2. By leaving it or sending it by post address to the corporation at the registered office, or if there is no registered office, then at any place where the business is in continuance. Sir, આખા order 29 rule 2 ની પ્રોવિઝનમાં કોઈ પણ જગ્યાએ મેન્ડેટરી સેલ શબ્દનો ઉપયોગ નથી કર્યો. એનો મીનિંગ એવો થાય સાહેબ either A or either 2. The servants can be served by any of the mode. એમનું જે કન્ટેન્શન છે કે it is mandatory to serve for the under subclause 2A. And if it fails, then only you are supposed to file into subclause 2B. એવું પ્રોવિઝન સીપીસીમાં નથી. એમનું સાહેબ જે એમને સાહેબ કંપની સેક્શન 51 ની વાત કરીને સેક્શન 22 of 2013. Section 51 in the Companies Act, which says એનું પણ હેડિંગ એવું છે સર્વિસ ઓફ ધ ડોક્યુમેન્ટ્સ ઓન કંપની or corporation. A document may be served on a company or an officer thereof by sending it to the company or officer at the registered office of the company by post under a certificate of posting or by registered post, comma, or by leaving it at registered office. આની અંદર સાહેબ આ સેક્શન 51 or સેક્શન 20 of the Companies Act માં કંપનીને કંપની અથવા કોર્પોરેશનને સમન્સ કેવી રીતે સર્વ કરવો એના પર જ ઉલ્લેખ છે. આ 51 એપ્લાય ના થતું હોય તો સાહેબ સીપીસીમાં એવું લખવામાં ના આવ્યું હોત કે ભાઈ અંડર સબ્જેક્ટ ટુ સ્ટેચ્યુટરી પ્રોવિઝન્સ ઓફ એની એક્ટ. જ્યાં સુધી જ્યારે સાહેબ કંપનીઝ એક્ટ 51 સેક્શન 51 માં સ્પેસિફિક પ્રોવિઝન કરવામાં આવ્યું કે કંપનીઝને સમન્સ કેવી રીતે સર્વ કરવો, then we have to apply for the section 51. It is to be submitted there. The rule 2 of 29 indicates that the provision of 2 is not exhaustive, but this is subject to any statutory provision regulating the service of process upon the company. It is contended that section 51 of the Companies Act contains a statutory provision regulating the service of documents on a limited company, which includes summons, and such specific provision would prevail over order rule 29 or rule 2 of 29, order 29. Here in the case, the respondent number of the bank has served summons by registered post. The address of registered office was mentioned as we have. I will provide the certified copy of the trial court. Section 51 of the Companies Act, which deals with the service of documents on companies, ensures that the document may be served upon a company or any officer by sending it to the company. The expression document in section 51 is defined by section 2 of surplus 15 of the Companies Act. The document in view of the section 2 to surplus 15 of the Companies Act includes summons, notices, requisition, order, other legal processes, and registers whether issued, sent, or kept in pursuance of the any other act or otherwise. Section 51 ની અંદર સાહેબ સ્પેસિફિક ડોક્યુમેન્ટ શબ્દનો ઉલ્લેખ કર્યો. ડોક્યુમેન્ટની અંદર શું ઇન્ક્લુડ થશે એ પણ સાહેબ સેક્શન 2 સબ 15 ની અંદર કંપની એક્ટમાં ડિફાઇન કરી કે ઓલ ધી સમન્સ આર ઇન્ક્લુડેડ. In that view, when the rule 2 of order 29 provides for service of process in the suit against the company, subject, however, to any statutory provision regulating such service. In the matter of service of summons on a limited company, the provision of rule 2 of order 29 shall be subject to section 51 or section 20 of the Companies Act. The result is that the provision of section 51 or 20 would prevail over order 29 rule 2. Therefore, a summons on a limited company has to be served specifically in accordance with the section 59 or section 20 of the Companies Act. Sir, અરજદાર કંપનીએ કેસમાં જે દાવાના સમન્સનો ઉલ્લેખ કર્યો છે.
you are reading.
No, sir, it is point. It's just my point. સાહેબ વરદદાની કંપનીમાં સામાવાળા બેંક દ્વારા જે દાવાનો ઉલ્લેખ કરવામાં આવ્યો છે એ સ્ટ્રિક્ટલી ટુ ધી પ્રોવિઝન્સ પ્રમાણે જેમને સમજની બચાવણી કરવામાં આવી છે. Please, sir, work on it. સાહેબ આમાં એમને જે હેડિંગ પુટઅપ કર્યું છે એડ્રેસ શું લખેલું છે તો ડિફેન્ડન્ટ નંબર 2 એનસી નેશનલ પોલિટિકલ જજમેન્ટ નું સાહેબ ના નહીં
ક્લેપ મૂકેલી
ક્લેબ મૂકેલી છે
અચ્છા
પોસ્ટ ટાઇટલ છે સાહેબ શૂટનું.
સાહેબ મેં દેખાડ્યું એ જ પેલું 14નું પાનું જે દેખાડ્યું જી 14નું પાનું દેખાડ્યું.
It is very well mentioned here that the address of the company National Collateral Management Services Limited, address D164 TTC Industrial Area, Nehru GIDC, Mumbai. સર મેં ફ્લેટ મારી ત્યાં જે આરબીટી સ્લિપની કોપી મૂકેલી છે એમાં મેં હાઇલાઇટ કરેલું છે સેમ એડ્રેસ નેમ ઓફ કંપની કોપી मैं अपने का पेज कॉपी आपको which shows the website of the company ncml.com. You know, registered addresses on the very left side, sorry, on right side, contact us na niche લખેલું છે નીચે એની નીચે સર D164 TTC Industrial Area, Nehru MIDC, Navi Mumbai. Till today, there is the same address in the company's website. The company आज जगह पर operate कर रही है. Either they are operating from this office, either they are registered at this address. We are not concerned with
But we are disputing that. Right.
I will give you charge.
No.
CPC order 29 rule 2. We are focusing on order 29 rule 2 and the companies at section 51. Sir, એક પણ પ્રોવિઝનમાં એક પણ જગ્યા પણ એવું નથી દર્શાવેલું કે સમજની રજિસ્ટ્રેશનથી બચાવણી કરતા સમયે ઉપર કયા જવાબદાર અધિકારીનું નામ લખવું, ડિરેક્ટરનું નામ લખવું અથવા અધિકૃત વ્યક્તિનું નામ લખવું કે એવું એક પણ પ્રોવિઝનમાં જણાવેલું નથી. VK Construction Works Limited and others versus Messrs. Abdul Khalik and others. So, number delay High Court judgment. On page number 4, there is a highlighted fact. 4. Which says that as per para number 13, last 4 lines. As per order 29 rule 2 CPC, the summons on the corporation may be served by leaving or sending it by post, addressed to the corporation and registered office, or if there is no registered office, then any place where the corporation carries on business. To the same extent, is the provision under section 51 of the Companies Act regarding the service on company. Order 29 rule CPC and 59 as mentioned below. I already mentioned. Having seen all that, it appears that when the service was duly effected upon the appellant, was no need of issue of service by publication. However, the learned joint registrar cautiously proceeded to the issue of service by publication in Indian Express. It also taken the precaution of getting publication effected at both the registered address as well as the principal office of the company in Chandigarh, Delhi. So this segment shows that the section 51 of the Companies Act prevails over order 29 rule 2 of CPC. Sir, now specifically now come with my case. In this case, the postal acknowledgement, the online delivery status shows that the summons was properly and correctly addressed in the name of the company and to its registered office. It is very much clear that we have completely complied the provisions of order rule 29, rule 2 of the CPC. Under the said provisions, the service would be proper if the notice is sent by the post address to the company at the registered office, which was already mentioned. When this mode is already resorted to, there is no question of the delivery of the postal article personally to the administrator. હું સર કંપનીના ડિરેક્ટરને કે કંપનીના કંપની સેક્રેટરીને ઓથોરાઇઝ્ડ ઓફિસરને જ નોટિસ બજાવું, એમની જ ઓફિસમાં એમને જ સહી કરાવું તો જ નોટિસ બજા ગણાય એવું જરૂરી નથી. ઓર્ડર 29 રૂલ 2 CPC ઇઝ વેરી મચ ક્લિયર કે ભાઈ તમારું પોસ્ટલ એડ્રેસ પર તમારું ઇટ ઇઝ તમારી બજાવણી થઈ ગઈ છે. ઇટ અમાઉન્ટ્સ ટુ ક્લિયર delivery of summons. The notice was not merely left at the registered office of the company, but it was actually sent by the registered post at the registered office, which is perfectly legitimate and valid mode of service as per the provisions of CPC. There is a distinction between the first part of the order rule 2B and rule 2B or 29. That is the mode of service by leaving summons at the registered office, and the other mode is by sending it by post at the registered address of the company office. It has been clearly observed that by the Honorable Supreme Court and as well as the various High Courts that by registered summons to the registered address of the company is by post is a good mode of service. It is nowhere mentioned that it is the only way of the service that it must have the address or the name of the authorized person of the company in the summons. In the present case, it is very clear from the postal packet or delivery that the address of the registered company was clearly mentioned. The acknowledgement receipt bears the rubber stamp of the company and also bears the signature of the employee of the company. Thus, the service in this case is effected in compliance of the third mode of service under Rule 2 of Order 29. Sir, અંતર કંપની જ્યારે અપીલ દાખલ કરી ત્યારે કેટલીક બાબતો એમને છુપાવેલી છે. વાદી જે બેંક દ્વારા જ્યારે ફર્સ્ટ પહેલી વાર દાવો દાખલ કરવામાં આવ્યો નામદાર સિવિલ કોર્ટ ત્યારે પણ કંપની વતી કંપનીના એડવોકેટ વિદ્વાન વકીલ શ્રી હાજર થયેલા છે. સિવિલ કોર્ટ નામદાર સિવિલ સિવિલ કોર્ટમાં સર જ્યારે દાવો દાખલ થયેલા ત્યારે કંપની વતી એમના એડવોકેટ શ્રી હાજર થયેલા છે. કંપનીએ જવાબના રિપોર્ટો પણ આપેલા છે, ઇવન જવાબ પણ રજૂ કરેલા છે. Yes. And it is there in the original record is with the Honorable Commercial Court. એટલે સાહેબ આજ તારીખ સુધી એમને ક્યારે જાણ નથી થઈ, બજાવણી નથી થઈ, એવો જો એ કેસ લઈને આવતા હોય તો ઇટ ઇઝ એ ક્યારે કન્સિડર થઈ શકે એવો છે. કેમ કે સાહેબ એમને આર્ગ્યુમેન્ટમાં જેમનું એડમિશન હતું કે સમ ઓફ ધ કેસીસમાં અમને નોટિસ આવતી then we came to know there are some other cases are already filed. એટલે સાહેબ ઓલરેડી કેસીસ એમને નંબર ઓફ ટાઈમ સમન્સ વધેલા છે, એ અપિયર થયેલા છે. Sir, we have filed more than 185 suits on behalf of bank. We have all the Honorable Civil Court had issued summons from their end also. Subsequently, on non-delivery, we have also issued a registered post ID from our expenses, from the expense of the bank. Sir, દાવો દાખલ વખતે સમન્સ બજાવ્યા, દાવો પરત લીધો, ટીમ્સમાં ગયા. સર, પ્રી ઇન્સ્ટિટ્યુશન મેડિસિનની સિસ્ટમ એવી છે તો ત્યાં મિનિમમ 2 વખત સમન્સ નોટિસ ઇસ્યુ કરે છે. એ બંને વખત સમન્સ ઇસ્યુ થયો. નામદાર કોમર્શિયલ કોર્ટે અમે આપણી કોમર્શિયલ કોર્ટમાં નવો ફ્રેશ દાવો દાખલ કર્યો ત્યારે કોમર્શિયલ કોર્ટે ફરીથી સમન્સ ઇસ્યુ કર્યા. ઓન એન્ડ અબાઉટ મોર દેન 550 ટાઈમ્સ ઇન ટોટલ એક જ કંપની એક જ પ્રતિવાદી નંબર આઈધર 3 આઈધર 2 સમન્સ ઇસ્યુ થવા છતાં 50% કેસમાં બંને સમન્સ બચ્યા. તારીખે 185માં સાહેબ દાખલ કર્યા, 97માં એમને અપીલ દાખલ કરી. That means કે 95માં એ હાફિયર થઈ ગયા. 95 કેસીસમાં સાહેબ એમને સમન્સ બચી ગયા, બાકીના 97માં ના બચે સાહેબ એવું કોઈ માનવાનું કારણ નથી. કેમ કે એમની અરજીમાં પણ એમને કોઈ જગ્યા એવું લખેલું નથી કે એમને આ તારીખે ખબર પડી અથવા અમે આ કારણથી એમને અહીંયા હાથ જાણ કરી, અમે આ મેટરમાં હતા ત્યારે એમને જાણ થઈ, એવું એમને કોઈ પણ જગ્યાએ એમનું કન્ટેન્શન નથી. Therefore, it can be prima facie seen that the appellant is having full knowledge about the present case. The present commercial suit of the appellant has not appeared. Even after the service of summons duly served upon the through registered post, in the commercial suit the appellant has not appeared, and the honorable court has closed their right to file WS. Even સાહેબ 120 દિવસ પહેલા તો અમારી અરજી કોર્ટ સ્વીકારતી નથી. નામદાર કોમર્શિયલ કોર્ટમાં 120 જ્યારે સમન્સ ની 120 દિવસનો સમયગાળો પૂરો થવા બાદ અમે અરજી કર્યા બાદ નામદાર કોર્ટે ડ્યુ ડિલિજન્સ કર્યા પછી જ સાહેબ એમનો રાઇટ ક્લોઝ કરેલા. We have already produced all the original RPD slip online delivery status of the Indian Post, that is government website. We have nothing to do with the website or online tracking system. We have changes and modification. We are just putting the printout of the online delivery status of the RPD slip. Therefore, there is no reason to not believing the RPD slip and the register delivery status from the Indian government website. The appeal of the appellant company is against the provision of commercial court, and therefore I would request the honorable court that such appeal is not maintainable and liable to be dismissed. The honorable court has provided sufficient opportunities to the appellant company. The honorable commercial court has provided sufficient time of 120 days to comply with the for filing of WS. Sir, हमने हमारे लंडन फ्रेंड ने जो जजमेंट रजू करी सुप्रीम कोर्ट में, સર એ જજમેન્ટ પણ એવું નથી કે જો ઓર્ડર 29 રૂલ 2B પ્રમાણે સમન્સ હોવો કમ્પલસરી છે અથવા 2A ઇઝ નોટ મેન્ડેટરી એવું આ જજમેન્ટ નથી કહેતું સર. There is no such statement of the Honorable Supreme Court or any of the High Court that ordered summons delivery by order 29 rule 2A. Therefore, considering the provisions of the order 8 rule 1, order 5 of rule 1, which are mandatory in nature, the honorable commercial court has rightly decided and closed the rights of filing of WS in the commercial suit. I would request honorable court to dismiss this appeal filed by the appellant. That's it.
It's said हमारे consider it.
सर 5 आएंगे. Sir, as far as you are three years. First, I'll deal with the section 51 of argument. If your lordship would see all the three judgments, which is with regard to Supreme Court or the two Bombay High Court as well as Delhi High Court. As far as all the three judgments are concerned, your lordship, admittedly, those judgments are with regard to private limited or public limited companies. Supreme Court does not go into section 51 or section 20 of the Companies Act. They only, because even therein, the suits are filed against the company. The Supreme Court is not considering section 51 or section 20 of the Companies Act, being fully aware of the fact that the procedure which is laid down under CPC would be applicable and not under Companies Act. And that's why, if your lordship once again would kindly turn to para 8 of Shalimar, the Supreme Court judgment. I'll not bother your lordship with the other two judgments. And if your lordship would see the name Shalimar Rope Works Limited, which is basically limited means it would be under the Companies Act. And thereby, if what my learned friend is saying that the section 51 of Companies Act would be applicable, then in that circumstances, there was a proper service. If we take an anomaly that for a suit which is filed under civil CPC, if section 51 of the Companies Act is proper, because section 51 says you are just supposed to deliver it at the registered office, then this question would not have arisen before the Honorable Supreme Court. Now, in that light, if your lordship would once again read section para 8. Sending summons to a corporation by post addressed to at its registered office may be a good mode of service either by itself or preferably by way of an additional mode of service. But leaving the summons at the registered office, if it literally interpreted to say that the summons can be left anywhere unkept for in the registered office, that will lead to anomaly and absurd results. It has to be read in the background of the provision contained in Order 5/17 of the Code. In other words, if serving peon or bailiff is not able to serve the summons on the secretary or any director or any other principal officer of the corporation because either he refuses to sign the summons or is not to be found by serving person either after due diligence, then he can leave the summons at the registered office of the company and make a report to that effect. So, firstly, it has to be served upon the authorized person and then it can be left. Without serving upon the authorized person, it cannot be left anywhere wherever a person feels like. So, Supreme Court taking into consideration that this is what is contemplated under the provisions of CPC and does not take into consideration because over here also it's a company which is registered under the Companies Act and thereby if the provisions of Companies Act were to be taken, then there was a proper service. But what is required to be taken because it's a suit which is filed under the CPC, so the provisions of CPC are required to be taken into consideration. And thereby Supreme Court says that first 2A has to be done and thereafter if 2A is not done, if 2A is done, thereafter 2B comes. So this was my response as far as. Now, if you lordship the other submission that we have appeared in 95 and thereby our it has to be assumed that we are aware of it. The same submission is my submission. If I have appeared in 95, what would I achieve by not appearing in the other suits? I also make the same, I take my learned friend's argument to be as it, because otherwise not appearing is not going to be beneficial to me. It's going to prejudice my rights only. So there was no reason that I appear in some matters and I don't appear in other matters. It was not going to benefit me by any stretch of the way. So in my humble submission, lordship, as far as the other two judgments which have been which my learned friend has been relied upon, as far as 120 days is concerned, that judgment is concerned Supreme Court. I am not disputing that. That's something which I have already told. As far as servants is, because I have already stated in my petition also that I'm as far as that submission is concerned, that I am accepting. That I cannot run away from that. As far as the judgment of VK construction is concerned, if your lordship would see the VK construction, para 13 and 16, in that also, if your lordship would see the registered office, they could not serve upon. So by publication, there was served. And thereafter, in the end, it has been stated 17 that the appellant company mainly comprised of family members. They were neither rustic villagers nor illiterate to be unaware of the court proceedings. In that circumstances, so over there, the facts are completely different. So that's my humble submission also.
So then point 2 खुलासा करो. સર અમે એમનો જે શાલીમાર વાળો જજમેન્ટનો પેરેગ્રાફ નંબર 8 રિફર કર્યો છે એ જ બે લાઈન ખાલી વાંચો. Sending summons to a corporation by post address to it at its registered office.
Para 8, Salim.
Yes.
સર એ જ બે લાઈન રિફર કરું છું એમની. Sending summons to a corporation by post address to it at its registered office may be a good mode of service either by itself or preferably by way of any additional mode of service. Additional mode of service. But leaving the summons at the registered office of the corporation, if it is literally interpreted to say that the summons can be left anywhere uncared for in the registered office, my point is that our summons has not been left anywhere in the company. It was completely served through a registered post address, and we have received, and the item delivery was confirmed by the department of the post. One more. here very much we emphasize on the left. We have not left the post summons at anywhere in the registered office. We have completed delivered. We have got the signature of the post department. Got the signature of the someone authorizing someone authorized being the standing or sitting there, and submitting the online status. One more thing, my lord, that એમનું એક સબમિશન એવું છે કે જો આ દાવો કંપનીઝ એક્ટમાં દાખલ થયો હોય તો જ સેક્શન 51 or 20 એપ્લાય થાય એવું સેક્શન 51 or ઓર્ડર 29 રૂલ 2 CPC માં એક પણ જગ્યાએ મેન્શન નથી કર્યું. Even otherwise, considering we are forgetting the section 51 and 20, we are completely emphasizing order 29 rule 2. There is a complete statement of word or. There is no such mandatory provision of 2A or 2B. Therefore, this is not a mandatory to serve under the provision of order 29 rule 2B only. That's